154634. Good morning, everyone.
Good morning, Your Honor.
Morning, Your Honor.
Before the court hears arguments, the court has granted permission from an individual in the courtroom, Mr. Curry, who was kind enough to ask the court for advance permission to film this morning's proceedings. The court granted that request, but if either or both of the parties have any objection, the court will hear any objection after the fact. Ms. Dalton, any from the state of Washington?
No, Your Honor.
Thanks. Mr. Lamb, any from your clients?
No objection, Your Honor.
Thanks. Mr. Sprung, good morning.
Oh, no, I'm Mr. Syed.
Mr. Syed, good morning, I apologize. So the matters or issues before the court are these state's motions to dismiss counterclaims.
Yes, Your Honor. May it please the court. I'm Assistant Attorney General Todd Syed. I'm here with Linda Dalton on behalf of the state to argue the state's motion to dismiss the defendant's counterclaims. As set forth in the state's motion, the counterclaims are deficient because they are not cognizable claims and because the legal theory relied on by the defendants that the complaint has been rendered unconstitutional based on purported prosecutorial bias, quote, has absolutely no legal support. Not surprisingly, defendants offer no legal authority for their counterclaims in their response because since none exists. The only case they do cite, San Juan County versus no new gas tax, which I'll address, is wholly irrelevant to their counterclaims. In this argument, I plan to briefly discuss the complaint and the counterclaims, which we have divided into two groups, the relief counterclaims and the filing counterclaims, for ease of reference. I will then turn to why the relief counterclaims and then why the filing counterclaims should be dismissed. And lastly, I'll discuss the single case relied on by the defendants, no new gas tax, to show why this case provides no support and is indeed completely irrelevant to their counterclaims. This case involves significant violations of the state's campaign finance laws. The state has alleged the defendants engaged in a scheme that caused over $300,000 in contributions to be misdirected to defendant Iman for his personal use, and that Iman attempted then to conceal this scheme by causing false information to be reported to the state. Based on the violations alleged in the complaint, the state has asserted claims against Mr. Iman and the other defendants under the Fair Campaign Practices Act. And as to Mr. Iman only, the state has included a request for injunctive relief in this complaint to prevent Mr. Iman from continuing to access contributions for his own personal use in violation of state law. Although this relief request is contained in the state's complaint, at this time the state has not yet sought an injunction, and this request has not been taken up by the court, let alone imposed by the court. In response to the complaint, the defendants have asserted 8 counterclaims. Although defendants fail to mention the substance of any of these counterclaims in the response, the state has, for ease of reference, divided them into 2 groups based on their substance. 4 of the counterclaims challenge the constitutionality of the state's request for injunctive relief against Mr. Iman, referred to as the relief counterclaims. The remaining counterclaims allege that bringing this case is unconstitutional because of something they have labeled as prosecutorial bias on the part of the Attorney General. And we've referred to those as the filing counterclaims. Turning to the relief counterclaims first. The relief counterclaims should be dismissed. As an initial matter, the injunction is only requested as the defendant Iman. As a result, the relief counterclaims should be dismissed to the extent they are being asserted by any other defendant for that reason alone. With respect to defendant Iman, the relief counterclaims should be rejected because they are not cognizable claims, but instead seek an improper advisory opinion on a hypothetical injunction that has not yet been imposed. Further, even if this court were to reach the merits with respect to the injunction, defendants have not provided a single authority suggesting that such an injunction, similar to the one being requested, in the complaint that is expressly permitted by statute would be unconstitutional. As stated, the relief counterclaims are not cognizable counterclaims, but rather they are a defensive argument regarding the relief request that has not yet been imposed. Not surprisingly, a counterclaim has to be a claim. Merely disputing a relief request does not constitute a claim. In other words, no discernible cause of action is being asserted. Any concerns regarding the injunctive relief request can be appropriately argued when the issue of the injunction request is taken up by the court. Defendant's only argument for trying to salvage these counterclaims is by referencing the Declaratory Judgment Act. But this act cannot be invoked to seek an advisory opinion from this court on a hypothetical injunction that has not been imposed. The Walker v. Monroe case provides this court with direction on how to handle the issue. In that case, the Washington Supreme Court dismissed the declaratory judgment action, challenging the constitutionality of an initiative that had not yet gone into effect, stating that it would be an improper advisory opinion. The deficiencies here are even more pronounced than those addressed by the court in Monroe, since not only has the injunction not taken effect, the precise terms of any injunction that this court may impose at some future time are unknown at this time. Finally, even if an injunction existed, defendants have provided no legal authority at all in the response for finding the requested injunction to be unconstitutional. The Fair Campaign Practices Act provides for this relief, and the actual release request, as opposed to the defendant's kind of exaggerated description of it, is tailored to the defendant's alleged misconduct in this case. We've cited cases in our papers upholding the constitutionality of the Fair Campaign Practices Act. So in sum, the relief counterclaims should be dismissed because 1, they are not cognizable claims, 2, they seek an impermissible advisory opinion, and 3, defendants have provided no legal authority for finding the requested injunction to be unconstitutional. Now turning to the filing counterclaims. The filing counterclaims should be dismissed as well. In these counterclaims, the defendants allege that the complaint itself is unconstitutional because the Attorney General is purportedly biased against them. However, prosecutorial bias is not a claim, and allegations of such bias do not give rise to any constitutional claims. There is no legal authority for defendants' prosecutorial bias theory. None. The state has not found any, and more importantly, the defendants have not provided any. There's good reason this theory is not found anywhere in the case law. If it were, the personal views of prosecutors could be raised by defendants in many cases in the hopes of allowing them to avoid responsibility for their legal violations. Now turning to the defendant's response brief. It is noteworthy that it does not contain substantive arguments supporting the counterclaims. Indeed, there's no mention of the specifics of any of the counterclaims. Instead, the defendants argue about their right to assert counterclaims, which is not an issue. The only case relied on from the response, the San Juan County versus No New Gas Tax, is irrelevant and does not support defendants' counterclaims. By relying on this one case, they are trying to make their counterclaims fit into a single basket where it does not belong. So let's talk about No New Gas Tax. In No New Gas Tax, officials charged the political committee with violating the act by failing to disclose a purported campaign contribution that occurred in the form of an on-air radio support for an initiative. Only after the trial court had entered a preliminary injunction finding the on-air support was a contribution under the act, subject to disclosure and contribution limits, did the political committee assert constitutional counterclaims, which were dismissed. On appeal, the Washington Supreme Court held that the on-air radio support did not constitute a contribution under the act. Because the act was found not to require disclosure, the Supreme Court expressly did not consider the merits of the constitutional counterclaims. The Supreme Court nevertheless reversed the dismissal of those counterclaims and remanded them for future proceeding because the trial court's dismissal of them was, quote, an incorrect legal conclusion that the radio broadcast at issue were a contribution subject to regulation under the act. So it was not on the merits but rather on an incorrect ruling about what the act meant. This case is irrelevant for several reasons. First, the Supreme Court did not rule on the merits of the counterclaims. Contrary to defendants' contention, the Supreme Court expressly did not make findings regarding the substance of the counterclaims in that case. Secondly, the trial court's substantive ruling and injunction imposing harm on the committee occurred before the counterclaims were filed. So this is a situation that is far different from this one, where counterclaims are being filed in relation to an injunction that has not been imposed and obviously therefore is not having any impact on the defendants. Thirdly, in any event, the counterclaims asserted in no new gas tax were of substantially different character from those being asserted here. Those counterclaims related to an alleged abridgment of constitutional rights caused by an incorrect interpretation of the act that required on-air radio support for an initiative to be treated as a campaign contribution. Defendants here have not based their counterclaims on any underlying constitutional harm, but instead complain only about a request for an injunction that has not yet occurred and that the Attorney General is biased. In conclusion, the state requests that all of the defendants' counterclaims be dismissed with prejudice. There were two other issues that were raised in our papers. One is that the state points out that the court has discretion to strike redundant affirmative defenses. This became an issue last week when defense counsel argued on motion to quash that even if their counterclaims are dismissed, they have affirmative defenses. However, logically, if the court agrees that a bare allegation of prosecutorial bias does not give rise to constitutional counterclaims, the same conclusion applies to those affirmative defenses based on the same legal theory. And finally, the state has requested sanctions. The state incurred costs drafting the filing a notice of non-receipt of defendant's response. Only after this notice was drafted and served did defendants finally file a response. Given that this is not the first time defendants have filed a late response in this case, state requests $500 for additional expense for having to prepare the notice. Thank you.
Thank you. Mr. Lynn.
Thank you, Your Honor. May I approach?
Yes.
Good morning.
Good morning.
The state's motion fundamentally misunderstands the nature and purpose of a dismissal pursuant to Civil Rule 12b-6, and as well as the very nature of claims to vindicate First Amendment rights. 12b-6 motions are to be granted sparingly and with care, and only in the unusual case where the plaintiffs show on the face of the complaint an impossible bar to relief. So said the unanimous majority in No New Gas Tax. The court assumes that all of the facts alleged by the non-moving party, in this case my client, even hypothetical facts, are true. The classic example of a successful 12b-6 motion is where the statute of limitations has run. Even if everything that the plaintiff alleges in the complaint is true, if he failed to timely file the complaint, he loses as a matter of law. Here the defendant alleges in its complaint that its constitutional rights are threatened by the actions of the plaintiff and the conflict of the prosecutor in this action, and seeks unique and specific damages and relief associated with those claims.
Tell me what that relief, what relief is being sought with respect to the counterclaims.
There are multiple sorts. There's damages that are being
Okay.
sought, there's attorney's fees, and there's declaratory judgment that the relief that is being sought is unconstitutional.
Okay.
And you're
So you're seeking, your clients are seeking damages with respect to the counterclaims?
absolutely, and
Okay.
I'll address that. I mean, that's actually in the face of it. It's in page 19, as I cited on my
Okay.
brief. It's there. The state didn't acknowledge it, but it is actually there in the relief. With respect to the constitutional claims, the state first asserts that they are premature and hypothetical. Both arguments fail. First and most obviously, the state cannot ask for specific relief that implicates First Amendment rights of the claimant and then insist that it is premature to discuss it. I didn't put the relief that the state is seeking in their complaint, the Attorney General did. And that's precisely what the state is doing now, when it simultaneously argues that the extraordinary relief it seeks is justified, but also that it's too early for this court to permit claims regarding it. As a procedural matter, this turns constitutional jurisprudence on its head. The defendants are required to raise these claims now because of res judicata in claims preclusion. If the defendant didn't raise these claims now and assert the unique relief that is associated with them, the fact that this court would have considered and ruled on the underlying issues and affirmative defenses means he would be precluded from arguing them ever in a separate proceeding. In short, if he doesn't seek these claims now, he could never seek them in the future. The state's other argument is that the defendants have to be the subject of a fully completed constitutional violation before he can seek relief. That's just not how First Amendment jurisprudence works, Your Honor. It is safe to say that seeking to ban Mr. Eyman from serving as an officer of any political committee for the rest of his life will cause a chilling effect on his speech rights. And one need not reach for a hypothetical to understand the practical implications of this. We just received our trial date this week, Your Honor. Our trial date is October of 2018. Mr. Eyman is currently an officer of a committee that seeks to place an initiative on the November 2018 ballot. The state's chosen remedy would hang over the entire election and have a profound and impermissible chilling effect. The Attorney General specifically elected to place this extreme remedy in the complaint, and he has discussed it with great relish publicly. He cannot now seek to preclude any claims regarding the same as a matter of law. The defendants assert identical due process and take care constitutional counterclaims as the defendants in No New Gas Tax. Both claims assert that the prosecutors are financially, not mere biased, but that there is a financial conflict and that they are also ideologically conflicted. The state cryptically responds that the fact that a state official charged with enforcing the law may have an interest in doing so is not a basis to dismiss the claim. Your Honor, that's not in front of the court. That's not in front of the court. These claims is not at issue in this hearing. The claim here is that the Attorney General is violating the due process rights of the defendant by personally profiting from the litigation. For purposes of this motion, this must be assumed to be true. That is what is stated in the counterclaims. For the state to win this motion, this court would have to find that it doesn't matter if the Attorney General is personally profiting from this litigation. He is entitled to do so as a matter of law. This court should decline the invitation the state is offering to do so. The state's attempts to distinguish the No New Gas Tax case, which I was personally involved in, involves identical claims. But to the extent that this case is distinguishable from No New Gas Tax, the differences actually serve to undermine the state's purposes in this motion. In No New Gas Tax, the court had already made, albeit incorrectly, the critical legal determination of the case. Did the FCPA apply to the conduct at issue? The state's motion presumes that this legal question has already been decided, and it's been decided in the state's favor. But this court hasn't made that determination. You haven't decided whether or not the Fair Campaign Practices Act applies to the defendant's conduct, nor has the state even asked you to make that determination. As a result, the state's conclusory statements about the application of the FCPA have no force or effect in this proceeding. And indeed, to the extent that any assumptions are made for purposes of the 12b6 motion, they are made against the moving party and not for it. The state bizarrely asserts in its pleadings that defendants seek to punish the state with a dismissal of the charges. The defendants bring claims to vindicate their constitutional rights that are clearly implicated by the actions of the plaintiff, and they are entitled to do so at this time. Indeed, as we discussed earlier, procedurally, they have to do so at this time. This is not a difficult decision. The state, understandably but erroneously, seeks to have this court rule that the Attorney General is immune from constitutional claims as a matter of law in the Fair Campaign Practices Act. That is not the case. I will say this in conclusion: the state spends much of its time in its motion for 12b6 restating its claims and restating again its animus to Mr. Eyman. But something really leapt out at me in the reply, and I was relieved that the state said it again this morning. If you look at the footnote on page 10 of the reply brief, mind you, this is a reply brief, which is by definition of the civil rules limited to replying to my response. The court asks this, the state is asking this court to dismiss all of the affirmative defenses as well. And the state asks this in a footnote. A footnote. The state is seeking the relief that you would strike all constitutional affirmative defenses and all, in addition to striking all of the constitutional counterclaims. When I first read it, I honestly had to read that twice because I was like, first of all, you can't ask for relief in footnote. Second of all, you're not allowed to ask for a new relief in a reply brief. You're confined to a response. But Your Honor, I'm actually relieved that the state did that, because it points out what they're willing to do. Indeed, in a motion where they're asking for sanctions against me, they're willing to do this. They're willing to ask in a reply, in a footnote to a reply, that you strike all constitutional affirmative defenses. Your Honor, what this tells you is that the state will ask for anything, and they will ask for anything until this court tells them no. This case has just begun. You have not made any substantive rulings on the application of the Fair Campaign Practices Act to this particular litigation. This case has a right to be heard. My client has a right to have his constitutional claims heard. There is no basis in fact or law, and all the facts have to be assumed in our favor for you to strike this at this incredibly premature point. Thank you.
Thank you. Mr. Sack, you're up.
Thank you, Your Honor. I just have a couple of points I wanted to raise. The one thing I'll note from the response, just like the response brief, there's no citation to any authority for any of these claims at all. A counterclaims based on the constitutionality of an injunction that has not been imposed, no cases supporting that theory. In fact, as I pointed out in the law, the declaratory judgment action cannot be an advisory opinion. We don't have an injunction imposed. Just a simple request for relief can't be unconstitutional. So it's unclear whether he's just saying, just asking for relief is unconstitutional, or if he's talking about an injunction that hasn't been imposed is unconstitutional, but neither one of those, there's no support for finding either one of those to be unconstitutional. And secondly, with respect to the filing counterclaims, his pleading in the case versus his characterization of it now is that he says that the Attorney General used the litigation against citizen defendants to raise money for his 2016 election campaign. This is, first of all, this litigation didn't exist during the election campaign, but aside from that, he's not alleging about anything happening now. He's talking about this case being mentioned in connection with a campaign that happened in 2016. So to kind of rephrase the whole issue as he's making money off this case now is not a fair characterization, it's not an accurate representation of what has been pled in this case. So the last point I want to make, going to the bias, or what I'll call the filing counterclaims, on prosecutorial bias, I'm just going to say it once again, there is no legal authority for this theory that he's kind of putting on the court, and he's used the phrase prosecutorial bias. That's not the phrase I made up, that's the phrase he uses in his pleadings. There's no legal support anywhere in the case law for that to be a constitutional violation, and he hasn't provided any. So I'm going to go back to what the actual law is, and as far as I can see, there is no legal support for his theory, and no new gas tax doesn't provide legal support as well. Thank you.
Thank you. In preparation for this morning's hearing, the court, of course, read and considered the briefs of the parties and did some research independently with respect to the issues before the court this morning. And the court, prior to hearing arguments this morning from counsel, had pretty good idea of how the court was going to rule, and then something mentioned by Mr. Lamb this morning in his oral argument on behalf of his clients is compelling to the court, and that is the statement that his clients have a right to be heard. And they have a right to be heard with respect to constitutional violations raised against the state of Washington. Dismissal of claims is an extraordinary remedy. The court must be cautious in that regard. The court denies the motions to dismiss the counterclaims. The court denies the request for fees. I gave the state some additional time to respond. That's the ruling of the court.
Thank you, Your Honor.
Any other matters the court may take up this morning? Ms. Dalton?
Yes, I would anticipate that Mr. Lamb is going to renew his deposition notice. So for purposes of approaching that on the counterclaims, if the court could elaborate a little bit about what the parameters of those counterclaims look like, so when the inevitable deposition notice comes, that we'll have the ability to evaluate it to determine whether the Attorney General is actually the proper individual to answer those questions.
I'm not quite certain what it is you're asking the court to do.
Well, with respect to the counterclaims, the state argued that we couldn't find a legal cognizable
Right.
claim, and what the elements of that claim would be, just having a little more direction from the court about what the court anticipates those claims looking like.
I don't know.
Okay.
And if and when there's a notice of deposition, to take the deposition of Mr. Ferguson, and if there's, in response, a motion to quash, the court would make a ruling on that.
In anticipation of that, could we ask that in the event a deposition notice is issued, that it set out the parameters of the areas of inquiry? That would probably help the parties, and then if a motion to quash was necessary, then.
Mr. Lamb, what are your thoughts in that regard?
Your Honor, I have no objection to setting out the areas of examination. They would be the claims and counterclaims that we're, the affirmative defenses and counterclaims that we're raising. And I think that would be probably the specificity that I would provide in the notice. And again, I would tell the court, and I would tell opposing counsel that I will not spring a notice of deposition. I'm giving them notice now that will be forthcoming, but we can work on a mutually agreeable date and hopefully agree on times and appropriate restrictions before we bring this court with a motion to quash.
Okay, so the court doesn't believe it would be it is necessary for the court to make a ruling or enter an order with respect to the anticipated issues to be discussed or raised at a deposition of Mr. Ferguson. That being said, the court understands from Mr. Lamb that Mr. Lamb will provide that information or that framework to the state if and when his clients seek to take the deposition of Mr. Ferguson.
Yes, Your Honor.
Okay. Thanks.
Thank you, Your Honor.